A federal appeals court has now handed down a much-anticipated ruling in a case that started more than 5 years ago involving a St. Johns County transgender student. The legal battle began in 2017 after Nice High School student Drew Adams, a transgender boy, was barred from using the boys' bathrooms. Attorneys for Adams sued the district, and on Friday, an appeals court ruled that the district did not violate Adams' rights. News4JAX reporter Joe McLean's been digging into the court's decision. Says, Joe, what does this mean ultimately for school policy in Florida?
Well, Tarek, essentially, this is the court saying that when a school district makes a rule that a transgender student can't use the bathroom associated with his or her gender identity, that does not necessarily breach discrimination laws. Now, the question the court was being asked was, do those discrimination laws extend to protect one's gender identity? In a ruling from the 11th Circuit Court of Appeals, Judge Barbara Lagoa wrote, "This case involves the unremarkable and nearly universal practice of separating school bathrooms based on biological sex. The appeals court's main job here was to determine whether the school district's rule banning a student from using a bathroom tied to their gender identity is a violation of the 14th Amendment, which grants equal protection under the law. Judge Lagoa wrote, "We hold that it does not. Separating school bathrooms based on biological sex passes constitutional muster and comports with Title IX." But the entire court didn't agree with Judge Lagoa. Judge Charles Wilson wrote in a dissenting opinion that the ruling was made with the presumption that biological sex is accurately determinable at birth and that it is a static or permanent biological determination. In other words, if someone's sex is determined based only on biological attributes, then that determination should be subject to change if those attributes are changed. Drew Adams, now 22 years old, is the student who challenged the district and went to court hoping to change how it determines bathroom access to account for gender identity. Tara Borelli is the senior counsel of Lambda Legal, the firm representing Adams in this case. She released a statement to News4JAX saying this aberrant ruling contradicts the decisions of every other circuit to consider the question across the country. Transgender students deserve the same dignity and opportunity to thrive in school as all other students. The firm did not comment on whether they will appeal the ruling any further. And we did just receive a statement from St. Johns County Superintendent Tim Forson. He says, "We are pleased with the 11th Circuit Court of Appeals decision in the Drew Adams case. The court's opinion was supported by sound legal reasoning and common sense. Under this decision, this district will be able to protect all students' rights." The Supreme Court actually considered a similar case in 2021. That case involved a transgender student who was suing a school district in Virginia over the same type of bathroom access. The court in that case sided with the transgender student by dismissing the school district's appeal. But that case did not set any nationwide precedent. Tarek?
So, Joe, quick question for you. St. Johns County is one of the fastest growing school districts in all of the state of Florida. How many students does this affect?
Well, that's a great question. The school district in St. Johns County has about 40,000 students attending. According to the court documents, about 16 students identify as transgender. Of course, though, we don't know how this ruling in the future could affect policies in other districts. Back to you.
Joe McLean, thank you, sir.